Hey, please, Lordship.
Yes.
I need to mention item number 4. Lordship, the learned counsel is on leave.
Who is the learned counsel?
HR Chaudhary.
Sr. Chaudhary.
Yes.
On the pair being made by Mr.
S. Taluka.
Appearing on behalf of Mr. Sr. Chaudhary, learned counsel for the accused. Resist and list the matter on.
After vacation.
Why? This is bail application.
Lordship, he is on leave. actually.
Oh,
HR Chaudhary, sir. Still,
no, we cannot adjourn the matter.
or
After
maybe
vacation.
I'll have 14.
When?
Matter may be fixed on 14.
14.
Yes, my Lordship.
Okay, 14. Yes. Any other matter?
Lordship, item 6, part-heard matter, Lordship, only for today now. It's a hearing, Lordship had heard it at some length, it's an NDPS matter.
Yes.
So maybe next week, Lordship.
Next week. When?
18 will do. 18.
18. Okay, on the pair being made by Ms. B. Sharma, learned counsel. No, learned amicus curiae. Resist and list the matter on 18. 18.
Lordship.
Okay.
Item number 1.
None appears for the accused on call. Resist and list the matter after 1 week.
Item 2.
Please, Your Lordship. Another related matter arising out of same PS case number is fixed on 13 for CD Lordship. This matter may be 13 may be taken
Heard Mr. Your good name.
Jaman.
Learned counsel for the accused and also heard Mr. P as a law court, learned additional VP for the state respondent. This application under section 439 services is prepared by accused Sikandar Ali, who has been languishing in jail in connection with Hazara PS case number 85 of 2024 under section 407 379 FAC. The learned counsel for the accused submits that the case area of Hazara PS case number 85 of 2024 has already been called for in connection with BA number,
1641.
and accordingly a pair is being made that on that day case area may be perused to dispose of the present application also. This is AB, not B. Application, applicant. Accordingly, it is provided that register shall list this AB along with DN numbers also. On that day, endeavor will be made to dispose of the present application after perusing the case. Okay.
Item 3.
Meet to Your Lordship. Lordship, on the last occasion,
Yes, I have asked you to
yes, two judgments.
two judgments. What is the copy of judgment?
My Lord, if I can go through that small paragraphs of the judgments,
Yes.
they come in very much in my favor. Actually. My Lord, I had it was 7/2001 9 SCC 618.
Have you-
My Lord, this case defines what instigation is.
Okay.
Your Lordship takes up paragraph 20. 20, my Lord.
Hmm.
Instigation is to goad, urge forward, provoke, incite, or encourage to do an act to satisfy the requirement of instigation, though it is not necessary that actual words must be used to that effect, or what constitutes instigation must necessarily and specifically be suggestive of the consequence. Yet a reasonable certainty to incite the consequence must be capable of being spelled out. The present one is not a case where the accused had by his act or omission by a continued course of conduct created such circumstances that the deceased was left with no other option except to commit suicide, in which case an instigation may have been inferred. A word uttered in the fit of anger or emotion without intending the consequence to actually follow cannot be said to be instigation.
Hmm.
My Lord, relying on this judgment, in fact, this subsequent judgment was also mentioned in the 2023 judgment that I had forwarded to Your Lordship. Another judgment was passed, 2019 10 SCC 188. This is a case of discharge. Supreme Court has taken this to be discharged. But just a small facts in this case, if your lordship takes up paragraph 2.
Hmm.
Paragraph 2, my lord. By the impugn order, High Court has discharged this appellant, the respondent. High Court, in the impugn order, the respondent accused were discharged by the charge framed against them under section 306, read with 34 of the Indian Penal Code. The victim daughter of the de facto complaint was a painter and artist. To improve her proficiency in English, first respondent was appointed as her English teacher. Respondent numbers 2 and 3 are his parents. They developed intimacy between the victim and the first respondent, Indrajit, in the course of coaching. In the allegations, it is the allegation of the complainant that the deceased victim and first respondent had decided to marry. To finalize the proposal of marriage, the victim had gone to the house of the first respondent on 5/3/2004. It is alleged that the victim went to the house of the first respondent, respondents 2 and 3, who are the parents of the first respondent, came out to raise shouts and addressed the victim as a call girl. The words uttered by the respondent number 2 and 3 as per the de facto complainant are, "You are a call girl. Why my son would marry you? We would give our son in marriage elsewhere." It is alleged in the complaint that at the time the first respondent did not protest against the version of his parents, and his daughter returned home and became mentally perturbed. On 6/3/2004, at about 1 p.m., the victim committed suicide. Paragraph 4, my lord. There were 2 suicide notes. In one suicide note, the deceased had stated that parents of the first respondent abused her in silly words by calling her a call girl. In another note, which was addressed to the first respondent, the deceased had stated that the father of the first respondent stigmatized her as a call girl, and the first respondent had not responded to such utterance. Further, it is stated that the first respondent is a coward. After conducting the investigation, charge sheet was filed under 306/34 IPC against all the 3 accused. Case was committed to fast track and numbered as so and so. Then they appeared before the High Court. High Court discharged them. Subsequently, state went for appeal in Supreme Court. Now paragraph 14 is the ratio. Paragraph 13 and 14 is the ratio, my lord. Paragraph 13 says, similarly, in the judgment of so-and-so, when any quarrel which has taken place between husband and wife, in which husband has stated to have told the deceased to go and die, this court has held that the suicide committed 2 days thereafter was not proximate to the quarrel, though the appellant was named in the suicide note, and the suicide was not the direct result of quarrel when the appellant used abusive language and told the deceased to go and die. 14. Judgments referred above support the case of the respondents, except stating that on 5/3/2004, when the deceased went to the premises of the first respondent, his parents, who are respondent numbers 2 and 3, addressed her as a call girl. At the same time, by applying the judgments referred above, we are of the view that such material is not sufficient to proceed with the trial by framing charge of offense under 306/34. It is also clear from the material that there is no goading or solicitation or insinuation by any of the respondents to commit to a victim to commit suicide. This is my case, my lord. Even suicide note, she has stated that why she has committed suicide. Here, nothing. The link that I was calling, I had called her prior to her death. Even that is not, no material is there.
Okay.
I'm deeply offended.
Yes, Mr. Devi.
My only respectful submission, your lordship, is the charge sheet has been filed. After investigation, your lordship, the charge sheet has been filed under section 306. So your lordship may kindly allow him to face the trial, your lordship. Should face the trial. The allegations to be proved or disproved after the trial, maybe your lordship, but at least he will be allowed to face, directed to face the trial, your lordship, because the charge sheet is already filed. So after investigation, the investigator officer came to the finding that he is guilty and to be charged under section 306.
Oh, the question is there sufficient material to frame charge against the accused? That is the question. If there is no material, there is no question of asking him to face the trial.
The witnesses, your lordship, had alleged it. So the allegations are there, your lordship. In my respectful submission, your lordship, since the witness have very clearly stated that except him, there was nobody. And there are allegations, your lordship, at page 25. If your lordship may kindly peruse.
25 of
Page 25.
the petition.
Of the petition, your lordship, of the appeal, page 25. I'm reading the vernacular part, your lordship. This is witness Pinky Kakoti. The mother, your lordship, the last line, your lordship. The vernacular, may I read, your lordship? আসামি কংকন দাসে মোৰ ছোৱালীজনীক বদনাম কৰি ভালপোৱাৰ সম্পৰ্ক কৰি এৰি দিয়া বুলি মনত আঘাত পায় তাই এই পদ বাছি লৈছে মোৰ কবলগীয়া ইমানে allegation is there, your lordship. Maybe after the trial he might not be convicted, your lordship, but the prima facie allegation is there, your lordship, at this stage. The mother has alleged it.
Heard Mr. D.K. Bhattacharya, learned counsel for the petitioner, and Mr. T. David, learned counsel for the respondent number 2, and Mr. P.S. Locker. Mr. Locker, do you have anything to submit?
Lordship, in the CDR lordship, in the CD part, CDR lordship, it is it reveals lordship that lordship on that day lordship he has 2-3 times she called with that the accused person lordship. And apart from that lordship, all the witnesses have stated lordship that though they came to know that
CDR is seized here in this case?
lordship.
It is not seized, and not provided also. Charge sheet does not mention.
Lordship.
Mobile sees CDR lordship.
Charge sheet does not mention as per page 54. Charge sheet only mentions sketch map, PM report, 3 seizure list that are a phone, 2 phones and 1 gamucha, dead body chalan and inquest report. Page 54 will indicate that.
CDR sees question.
But all the 3 seizure lists I have annexed is there.
On it again.
You have not gone through the CD.
Not entirely lordship. And CDR.
Then you go through it, we have little time, we have also some other matters to deal with.
Sanction.
On Thursday then,
Lordship.
only for your submission.
Lordship.
Heard Mr. D.K. Bhattacharya, learned counsel for the petitioner, Mr. T. Devi, learned counsel for the respondent number 2, and Mr. E.S. Locker, learned additional PP for the state respondent number 1. List the matter on Thursday,
13 June. 1-3.
so as to enable Mr. Locker to apprise this court about the materials available in the case 8.
Item 8,
Yes, it is it.
CD not received lordship. One prayer has been made by the IO lordship that due to some he is on leave lordship.
Okay, you remain on leave, then we will grant him this prayer.
I am not involved in the case any matter. Anyway, I am not involved in only because he is my partner in Tezpur. Not, I am related with land matters here in Guwahati.
Heard Mr. D. Gulsami, learned counsel for the applicant, and also heard Mr. P. S. Locker, learned additional briefing for the state respondent. Apprehending arrest in connection with dispute is case number 2497 of 2022 under section 420, 468, 471 IPC. This application under section 438 services prepared by applicant Imtiaz Anwar for grant of PRSP. The above noted case has been registered on the basis of an FIR lodged by one. Where is the FIR?
FIR is page 9.
On the basis of one
FIR
lodged
is,
by
in
one
FIR also my
Punya
name is
Devi
not
Narayan.
present.
On. When it was lost,
It was lost in 25/11/22.
on 24/11/2022. The sense of allegation made in the FIR dated so and so is that when deposit not along with one Ajoy Kumar Sharma and Pankaj Biswas manufactured forged registered instrument of general power of attorney being serial number 5646 and prepared a deed forged deed number 1139 dated 5/3/2022 and created false and fabricated deed of sale. I go to deed of sale now, deed number. Deed of sale document number 25478 and number 20542 dated
20542
2/7/2022
actually. Right side is taken as number.
with the help of sub-register Kamrup Metro and thereafter graved her land. Mr. Goswami, learned counsel for the applicant submits that the applicant is innocent and no way involved with the offense alleged in the FIR and he is the friend of accused.
Sure.
Whose friend?
Dispute police is inquiring about me in my house.
No, no. You have submitted that you were the friend of
Deposit not.
Deposit Nath.
Main accused.
Deposit
Already
Nath,
he is
who is
released.
the principal accused here in this case, and except this, he has no other relation with him. Any other relation with him?
No, nothing relation. He is my business partner in Tezpur,
He is the business partner of the.
construction business partner.
No, the applicant is the business partner of Deposit Nath, who is the principal accused here in this case. And except that he has no other relation and he is being searched by police and therefore.
He is the attorney holder also.
Attorney.
He is the attorney holder of the deed.
No, Tezpur attorney holder means attorney holder and for taking a plot
He is
of land, attorney holder is required. Attorney and two deed,
This is not.
general power of attorney and
Page 43.
development agreement.
Page
They
43.
have taken a land from other.
Page number
Page 43 Lordship. Imtiaz Anwar. He is the attorney holder Lordship. Of the
40?
fixed sale deed Lordship. Fixed deed Lordship.
No, he is
Within-
not attorney holder of fake deed. No, it is in
Page
Tezpur
number?
property. Tezpur property attorney holder. They have taken a plot in Tezpur by taking power of attorney from one person. Biplab Nath, Biplab Sen. I don't know.
Here next question.
এইখন মানে হয় কি মাটি এটা ল'ব লাগিলে এটৰ্নি ল'ব
জানো মই।
এইটোৰ লগত সেইটো কানেকশ্যন নাই এইটো আমি দেখুৱাইছো যাতে তেওঁ ইজ ইনোচেণ্ট এইটো মেইনত তেওঁ হেৰি নাই ইনভলভমেণ্ট নাই He is not involved. Nowhere his name is there.
And that he is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. It is to be noted here that by order dated 5/6/2024, the learned additional PP was directed to produce the case diary before this court, but the learned additional PP has failed to produce the case diary before this court. And submits that the IO is on leave and therefore prays for granting him some more time. Whereas Mr. Goswami learned counsel for the applicant submits that the applicant is innocent and no way involved with the offense police. And he has not been granted any interim protection and therefore it is contended that interim protection may be extended to the applicant till production of the case diary. But having heard the submission of learned advocates of both the parties and also considering the facts and circumstances on the record, this court is inclined to extend interim protection to the applicant till receipt of the case diary, and accordingly it is provided that the case diary be called for fixing the matter on when?
On 21st, 21 also.
Till then. No, in the interim, it is provided that in the event of arrest of the applicant in connection with case number so and so, he shall be released. Subject to satisfaction.
Item 5,
21 days.
I'm extremely sorry, Lordship. I have missed item number 1, Lordship.
Later on, Mr.
Item number 1, Lordship. I have missed.
What is your name?
K. Thakur, Lordship.
Thakur, learned counsel for the applicant present. Applicant or accused?
Petitioner, Lordship. Accused petitioner. Bail
BA.
application.
CD not received.
Okay, it's for motion,
Item number,
Lordship.
he is submitting for item number 1, Lordship.
Yes, item number
It-
1
it
is
was
in
motion,
motion
Lordship.
column.
Motion, Lordship.
Motion column.
Okay, CD, when?
Lordship, day after tomorrow for co-accused is fixed, Lordship.
Day after tomorrow.
Yes, Lordship. On 13/6/24 before this court, Lordship.
Okay,
Highly obliged, Lordship.
this Azara PS case.
Yes, Lordship. Highly obliged, Lordship.
MK Das.
item 5,
None appears for the appellant on call, raises and lays the matter after 1 week.
item 7,
DB cause list. No. Dr. Brian. Mr. Uddin, time is very short.
Lordship.
So your please, on the other day, you have referred one section. What was that section? 300 and?
300, my lord, explanation 1 and 4, right? 300 explanation regarding my lord, sudden provocation, man.
Sudden provocation or sudden fight?
My lord,
You are not sure.
sudden fight is not there, my lord, but sudden provocation is there, man. So
Fight is
that's,
not there.
in this 300, my lord, explanation not fight word is used, my lord.
No, sudden fight is a 304.
4, yes, my lord, yes, ma'am.
Explanation 4.
4, my lord. So, my lord, another, my lord, I have gone, my lord, regarding, my lord, probation of offender act, my lord.
Ah,
That, my lord, he was
no,
taken in the-
307 offense, how can the court grant you probation?
My lord, in some cases, my lord, I have seen, my lord, also granted, my lord, considering the, my lord, first offense.
Hmm. You take down it,
Lordship.
2003.
See, my lord.
9 SCC 322 page number.
Lordship.
Hiru Bhai, Burok Bhai Nayak versus State of Gujarat. This sudden fight is dealt with in this case, para number 21. No, sorry, para number 11.
11.
Hmm.
So.
Which part of this judgment it is dealt with?
Paragraph 10, 11 and 12.
Huh?
Paragraph 11, madam.
No, he,
This is for my side.
pardon?
This judgment cited by me, my lord, for the respondent.
Paragraph number?
10, 11, 12 regarding 307.
These are judgments quoted from other judgments. No, these are quotation from other judgments.
Lordship.
Where is the ratio of this case?
Nineteen.
Hmm. No, in that case, there was punctured injuries, 11 numbers
Lordship.
caused by a firearm.
Lordship.
So here only one injury.
No, this is in
How many injuries the victim suffered?
Three injury.
Three injuries.
three injuries.
One is overhead.
One is head, one neck, and another is, my lord, optical injury.
Simple.
So show me the judgment where it is stated that in the case of 307 IPC also this Prohibition of Offenders Act can be extended.
My lord, lordship may kindly see section, my lord. Yes, my lord. CIPC provision is, my lord, section 360. My lord,
360 is not applicable in Assam. Here Prohibition of Offenders Act is
yes, my lord,
it
section
is in
4, then
force.
probation act is, my lord, section 4.
uh,
4 deal with, my lord.
Prohibition of Offenders Act.
Lordship may kindly,
Prohibition of Offenders Act.
section 4.
Yes, read the section
My lord.
slowly.
Power of court to release certain offenders on probation of good conduct.
Hmm.
When any person is found guilty of having committed an offense not punishable with death or imprisonment for life, and the court by which the person is found guilty is of opinion that, having regard to the circumstances of the case, including the nature of the offense and the character of the offender, it is expedient to release him on probation of good conduct, then notwithstanding anything contained in any other law for the time being enforced, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties to appear and receive sentence when called upon during such period, not exceeding 3 years,
But that's
Yes.
all right, but can you show any authority in this regard?
my lord.
By which this Probation of Offenders Act is benefit of Probation of the Offenders Act is extended to the accused
Lordship.
convicted under section 307.
307, my lord, I have gone through some Supreme Court judgment, old judgment, my lord.
Ah.
My lord, it is, my lord, citation is there, my lord, 1988 AIR 2127, 1988 SC 4551,
Hmm.
1988 scale 2426, my lord.
Mm.
I found, and there's some judgment, my lord,
So how in the present case, this issue is dealt with by the trial court?
my lord.
In this case, also all the 7 witnesses has been examined, Lordship.
No, trial court.
My lord, trial court, my lord,
How the trial court has dealt with the issue of probation?
yes, my lord, it is only, my lord, she said, I have not given the benefit of that, my lord. Lordship may kindly see last part of the
Hmm.
order, page 25 in my petition, my lord. Page 25, my lord. Result of injuries and nature of injuries stated by the victim does not have much bearing the material part of section 307 IPC. It is the intention of the accused while inflicting injuries which might have caused her death. Prosecution has been able to prove beyond iota of doubt that the accused committed the offense under section 307 IPC. Considering the facts and circumstances of the case and the manner in which the accused committed the offense, I am not inclined to give him the benefit of the probation of Offenders Act 1958. Therefore, the accused stand convicted under section 307 IPC. However, there is nothing in the evidence of the prosecution warranting conviction of the accused person under section 498A IPC as the evidence of the prosecution witness are not found sufficient in this aspect, and as such, the accused person stand acquitted under section 498A IPC. Thereafter, Lordship may kindly see sentence, my lord. Page 28.
Hmm.
My lord, accused Sirajuddin is present. I have heard the learned public prosecutor as well as the learned counsel for the defense on the point of the sentence. Learned public prosecutor has insisted to impose maximum punishment as the offense committed by the accused is grave in nature and it has serious impact on society. On the other hand, learned defense counsel submitted that the accused is first-time offender having no criminal antecedent. The accused is also hard on the quantum of sentence. The accused has submitted that the punishment may be leniently considered. Considering the entire facts and circumstances of the case, the accused Muhammad Sirajuddin is sentenced to undergo 5 years RI and to pay fine of rupees 5,000 only in default. So, my lord, I have gone through many judgment, my lord, which, my lord, sometimes 1 year also given, my lord, sometimes, my lord, 2 years, 3 years, 4 years, less also, my lord, under
So here 5 years.
5 years, my lord. So, my lord, admittedly, he is the first offender, my lord.
Hmm.
Though there is the allegation of other case, my lord, there is no conviction as such, my lord.
Yes, this is the way to.
So in this cases, he was not convicted under section 307, though 307 was there.
My lord, 307, under section 307.
Where?
It's page 25, my lord.
No, in this judgments you have referred to,
Lordship.
this Sadaram and two others versus State of UP.
Yes, ma'am. In this case,
Where the benefit of a section
Lordship,
Probation of Offenders Act is extended.
please, my lord. That was, my lord, convicted under 306, man.
Where?
Lordship will find,
You come to page para number 20, that is section 360 CRPC has not been considered by the trial court and appellant deserve provision under section 325 IPC.
Lordship.
Here offense is 307.
My lordship is Sadaram and two others,
Ah,
judgment.
ah,
My lord, case was registered under section 307, my lord.
maybe, but not convicted under section 307.
Yes, my lord.
Huh?
He was, my lord, convicted. For the offense. But injury, just one injury also, my lord, in the vital part, my lord. This was considered, my lord. Lordship may kindly see page 26, my lord. Para 26, my lord.
Hmm. There the principle of section 360 CRPC is discussed.
Yes, my lord.
But where the accused was convicted under section 307.
Lordship.
Uh,
My lord, thus, the appeal is partly allowed the conviction as directed by trial court, my lord, para 31. Thus, the appeal is partly allowed the conviction as directed by trial court under section 307,
Hmm.
34 IPC is converted to section 325 IPC. As prima facie offense does not travel beyond the purview of section 325 IPC. Thus, the conviction under section 325, 34 IPC is confirmed and the appellant are directed to be released on probation under section 4 of the UP first
that
offender.
is after conversion of the sentence.
Yes, ma'am. My lord, he was converted to section
Not convicted under
325.
section, no,
25.
not appeal the sentence under section 307. You show me any judgment, any authority where
Lordship,
the accused is convicted under section 307
lordship.
IPC and the courts have extended the privilege of section 3 or 3 and 4 of the Probation of Offenders Act or section 360
My lord,
CRPC.
my lord, one judgment I refer Supreme Court, my lord.
Ah,
In this, this was also under section, my lord, the 307, 149.
where it is discussed.
Yes, my lord. That was last part, my lord.
Hmm.
My lord, that was, lordship will find.
So there 307 149 acquitted.
Lordship,
Hmm.
not.
Where the accused is convicted.
Lordship may kindly see. My lord, para 4, page 4, my lord. They use only the blunt side of its, despite they being attacked by the other side.
Hmm.
They suffered injuries, but not provoked or tempted to use the cutting edge of the weapon. It is very, very significant. It seems to us that they had no intention to commit murder. They had no motive either. The fight, as the High
No,
Court has.
no, he also that provision
Yes, ma'am.
360 and 3 and 4 of the Provision of the Offenders Act,
Lordship.
where it is discussed.
My lord, another judgment I have referred.
Hmm?
Lordship, my lord, Dinanath, my lord. One judgment, Lordship may kindly see Dinanath versus UP. Para 10, my lord. Thereafter, the learned trial court, after hearing learned counsel for the parties and the appreciating the entire evidence, oral as well as documentary, found the accused appellant Dinanath guilty and convicted the appellant under section 498 IPC. 1 year rigorous imprisonment with fine of rupees 1,000 under section 306 IPC for 3 years rigorous imprisonment with fine of rupees 1,000. Acquitted the other.
Oh, yeah, where is the 307?
Well, initially it was,
Not initially.
that was my lord,
Hmm?
306, my lord.
You show any authority where the accused is convicted under section 307
My lord.
IPC and the benefit of probation is extended to him.
Not good.
Hmm?
But
And
my
you
lord,
go through the judgment I have
lord,
referred to
yes, my lord.
in respect of this
And
sudden fight.
sudden fact, my lord.
Sudden fight. So when to be listed?
My lord. On 15. Before
On 21.
Before 27, my lord. 17, before 17.
Heard Mr. Ziuddin, learned counsel for the appellant, and Mr. A.C. Ahmed, learned counsel for the respondent number 2, and Mr. P.S. Lockwood, learned additional speaking for the state.
Yes, not about it.
List the matter on
20 June.
20. As parted.
Obliged.
আপনার